We are excited to offer probate services for families in El Reno, Oklahoma. A majority of probates are administered in long form, and they take several months and even years if the family is fighting. For lack of a better word, I call these, well, regular probate proceedings. The attorney will first determine if there is a last will or no last will at all. If the decedent, if your loved one, did not have a last will and testament, this is called dying intestate. The lawyer will draft an initial petition for probate, just like in the summary from the last video. If the client agrees with the wording, then the law firm will have them sign the petition and will file that petition with the court clerk. The judge that it's assigned to will order that petition to be heard at some future date, usually about 30 days into the future. Probate lawyers will publish notice of that hearing in the local newspaper and will mail a copy of the notice of hearing to all interested parties. This is usually done by certified mail so that we can prove that they got it and that we attempted to mail it to them. At the initial hearing, the court will usually make 4 determinations. At that hearing, the first one is, does the court actually have jurisdiction to hear the probate? If your loved one did not live in or have any property in the county, then the county court may not have jurisdiction. If your loved one did live in the county, then the court probably has jurisdiction. Number 2, is there a valid last will and testament, and should it be admitted into the probate? Number 3, who should be the personal representative of the estate? The executor or the personal representative is usually a family member, and it's usually the person who hired the probate attorneys to file the probate. Number 4, who are the legal heirs of the estate, the beneficiary? The judge will also issue an order stating exactly who the legal heirs are at that first hearing. This is important because these legal heirs now have the legal authority to consent to the sale of real property belonging to the estate. It is also helpful to know whether the estate is going to be split up 4 ways or 3 ways. Once the court has made these 4 determinations, it will usually appoint the petitioner as the personal representative. A personal representative is sometimes called the executor, depending on where you live, and is charged with administering the estate of the decedent. This involves gathering and identifying all assets, settling claims, administering this estate, and finally distributing what is left over to the heirs. Depending on your state, creditors also have 60 days from the filing of a notice to creditors to file a claim against the estate. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of your loved one. Again, this is usually done by certified mail. If the creditor files a claim against the estate, then the personal representative decides if it's a valid claim and should it be paid. That claim then must be approved by the court before any payment can be made. Next is a general inventory, which lists out all the assets. This list usually includes what is in the estate, such as real estate, personal property, mineral interests, financial accounts. When real estate or personal property needs to be sold to satisfy debt or to make money available for distribution, the personal representative will make application to the court for authority to sell assets like that real estate and personal property. Again, the judge must approve it. Now, earlier I stated that the court determines the legal heirs of the estate at the initial hearing, at that first hearing. Because the judge has made that determination, all the beneficiaries have the legal authority to consent to the sale of real estate or personal property by the personal representative. They have to give the personal representative permission. If they do, then the executor, the personal representative, can sell the house with a realtor, deposit the proceeds into the estate bank account. Now, this is a separate estate account, not the bank account that your loved one had during their lifetime. Once the personal representative has gathered all the assets, paid and settled all the claims, then and only then is the estate ready for closing. This is usually done by a final account, and you guessed it, we have to file it with the court and give notice of that pleading. Notice of that hearing for final account is published in the newspaper, mailed to all interested parties by certified mail, and usually set for 30 days into the future. So you can see that if everything goes perfectly, it takes 4 to 5 months. They never go perfect, and they usually last 5 to 7 months. If the family starts fighting, then it might even take years to complete a probate. We've had that happen on a regular basis where the family just couldn't get along, and it takes years because it's hard to get on the judge's schedule. It's hard to set those hearings and all of those motions where the family is fighting. The key is your family has to get along. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.